Hello friends, in this video I am going to discuss what is the meaning of judicial separation. Judicial separation is a transitional phase of a marriage where husband and wife are not obliged to live together, but at the same time they are not fully free from their marital relationship. So in this video, I will discuss the concept and provisions of judicial separation. Let's start with the concept. Concept of judicial separation. Fundamentally, the term judicial separation is used to indicate the matrimonial period where husband and wife are though separated, living separately, maybe in the same house or in separate houses, but they are not free from the bonds of their marriage. Now the question is, what does the court's order signify in reference to judicial separation? Under the order of judicial separation, the court prohibits husband and wife to cohabit together and insists them to live separately. Now, the next question is, what is the integrity of judicial separation? The fundamental integrity of judicial separation is to reinstate the marital relationship of a husband and wife, provided if there is any possibility remains there. In fact, because of life stress and some other problems, if a couple approaches court for the divorce in such a case, rather separating the couple permanently, that is divorce, judiciary gives a chance to them by giving the period of 1 year, that is judicial separation. In such a given period, if they reinstate their relationship, wonderful, or else they are free to file the case of divorce. Therefore, before granting the prayer to permanently snap the matrimonial relationship of respective husband and wife, every attempt should be made to maintain the sanctity of the relationship, which is of importance not only for the individuals or their children, but also for the society. Next, as defined by the Section 10(1) of the Hindu Marriage Act 1955, either party to a marriage, whether solemnized before or after the commencement of this act, may present a petition praying for a decree for judicial separation on any of the grounds specified in subsection 1 of the Section 13, and in the case of a wife also on any of the grounds might have been presented. Both the grounds are discussed in the following slide. Further, the Section 10(2) of the Hindu Marriage Act 1955 states that where a decree for judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court may, on the application by repetition of either party and on being satisfied of the truth of the statement made in such petition, rescind the decree if it considers it must and reasonable to do so. Now, the next question is, what is the period of judicial separation? In a normal circumstance, the period of judicial separation is 1 year. Next, what are the grounds of judicial separation? In normal circumstance, the grounds of judicial separation remain same as of divorce. Following are the common grounds on which either husband or wife can file a petition for the judicial separation: desertion, cruelty, adultery, insanity, renunciation of world by entering any religious order, conversion of religion, that is apostasy, virulent and incurable form of leprosy, or venereal disease in a communicable form. Some special grounds available only for the wife. Following are the special grounds exclusively available for the wife. If husband remarries or already married in his past, remarriage or earlier marriage of the husband, but solemnized before the commencement of Hindu Marriage Act 1955, provided the other wife is alive at the time of presentation of the petition for judicial separation by the petitioner. Cruelty and criminal activity that is related to rape, sodomy, or bestiality by the husband committed after the solemnization of his marriage with the petitioner. Non-resumption of cohabitation even after 1 year. Non-resumption of cohabitation between the parties till at least 1 year after an award of maintenance was made by any court against the husband and in favor of the petitioner. And if marriage is performed before she had attained the age of 15 years. That is, solemnization of the petitioner wife's marriage with the respondent husband before she had attained the age of 15 years, provided she had repudiated the marriage on attaining the age of 15 years, but before attaining the age of 18 years. Next, that is limitations. If the husband made sexual intercourse with his wife without her consent during the period of judicial separation, then it is considered as an offense under the section 376B of the Indian Penal Code. The husband may be awarded imprisonment of up to 2 years and fine. Secondly, under section 125 of the Criminal Procedure Code, the decree of judicial separation is no ground to refuse maintenance to the claimant wife. So this is all about the judicial separation.